Hey, so I am doing it super early today because it's my birthday, and I don't know what I want to do later, or if my husband has dinner plans or whatnot. So anyway, I'm going to go ahead and do lesson 7 now. Lesson 7, guided reading we're doing the book study. I'm using Teaching Tolerance's lesson plan for studying the book New Jim Crow by Michelle Alexander. I have the previous lessons on my blog, www.southernfriedsocialist.com, and that has all the previous lessons. To go directly to this lesson, click on the link that I have provided you, and then I'm going to go ahead and, let me see, and then also, on my website, I have a glossary. Because if you go to my website, the link that I've given you, it goes directly to the post that we're going over today. And it will have the vocabulary that you might not be familiar with on there. But every new word that we find as we go through things, I add to the glossary, basically. So, let me see. La 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 la. And then here is the link to the guided reading that I'm doing, the study questions that I'm asking you, and again, a link to the blog, just in case. Let's see. And then what else okay. I'm going to give you the footnotes as well. The endnotes are on the blog, but also as I'm going through them. And I probably will not, if a bunch of people come on or anything, I might not interact a whole lot because this is a very, very long, well, to me, it's one of the longer chapters. So there's your endnotes. Vocabulary is on my website, www.southernfriedsocialist.com. We're going over the New Jim Crow using Teaching Tolerance's lesson plan, and today we are on lesson 7, which is chapter 3. And I'm going to do like I did yesterday, and I'm going to read you the first 5 questions, and then halfway through the reading, I'm going to pause. I'm going to read you the next 5 questions, and then, because this is like a, this is you growing, us going over to this book. If you have something to say, definitely say it, but just, think about things. So, what is the dilemma? And by dilemma, I mean not merely a difficult choice, but a choice that one must make between 2 or more undesirable or unfavorable options. Describe the dilemmas faced by Irma Faye Stewart and Clifford Reynolds. What were their options? What did they each decide given those circumstances? Discuss the role of choice versus coercion in these instances. So as I'm reading, think about these 2 people and what they had to go through. According to the author, what is the public's perception about who represents the majority of drug users and dealers? What is, in fact, the reality? What primary reason does she offer for the misconception? Explain the meaning of this finding. Studies consistently indicate that drug markets like American society generally reflect our nation's racial and socioeconomic boundaries. By citing these studies, what larger point is the author trying to make? The author claims that the disproportionate number of African Americans incarcerated is due to a criminal justice system that discriminates based on race, yet is immune to charges of racial discrimination. How does this 2-punch work, according to her? What is unique about the activities associated with drug crimes? What challenge does this pose for drug law enforcement? That's our first 5 questions of our text-dependent questions, and then we're about to start. If you want the entire chapter being read by the author, it is on my blog as well. This is just the guided reading part that, like, if you only have 30 minutes or, 45 minutes and you just kind of want to listen to it in the background or before you go to bed, this kind of boils it down, and I've also got all the links. And then if you're trying to show this to somebody and you don't exactly want to do the reading for them, I'm tribute. The color of justice. Imagine you are Irma Faye Stewart, a 30-year-old single African-American mother of 2 who was arrested as part of a drug sweep in Hearne, Texas. I'm probably saying that wrong because when I first moved to San Antonio, I moved to Bexar County. And then they were like, oh, you're not from around here. And I was like, no. And they're like, it's Bear County. And I'm like, oh, okay. But it's Hearne, Texas. All but one of the people arrested were African American. You are innocent. After a week in jail, you have no one to care for your 2 small children, and you are eager to get home. Your court-appointed attorney urges you to plead guilty to a drug distribution charge, saying the prosecutor has offered probation. You refuse, steadfastly proclaiming your innocence. Finally, after a month in jail, you decide to plead guilty so that you can return home to your children. Unwilling to risk trial and years of imprisonment, you are sentenced to 10 years probation and ordered to pay $1,000 in fines, as well as court and probation costs. You are now branded a drug felon. You are no longer eligible for food stamps. You may be discriminated against in employment. You cannot vote for at least 12 years, and you are about to be evicted from public housing. Once homeless, your children will be taken from you and put into foster care. A judge eventually dismisses all cases against the defendants who do not plead guilty. At trial, the judge finds that the entire sweep was based on the testimony of a single informant who lied to the prosecution. You, however, are still a drug felon, homeless, and desperate to regain custody of your children. Now place yourself in the shoes of Clifford Reynolds, another African-American victim of the Hearne drug bust, Hearne. There's a footnote on that. You returned home to Bryan, Texas to attend the funeral of your 18-month-old daughter. Before the funeral services begin, the police show up and handcuff you. You beg the officers to let you take one last look at your daughter before she is buried. The police refuse. You're told by prosecutors you're needed to testify against one of the defendants in a recent drug bust. You deny witnessing any drug transactions. You don't know what they're talking about. Because of your refusal to cooperate, you are indicted on felony charges. After a month of being held in jail, the charges against you are dropped. You are technically free, but as a result of your arrest and the period of incarceration, you lose your job, your apartment, your furniture, and your car, not to mention the chance to say goodbye to your daughter. I'm going to pause and take a side note right here. Now, remember what happened in Texas right now where they drug a parent? There is a parents in Texas Children's Hospital right now. Their infant is waiting to get surgery, and ICE came and drugged those parents out of that hospital right before their infant's about to get surgery. Like, you know, and it was a brown couple. I mean, they weren't black, but they were Hispanic. I mean, it just kind of goes into showing racism and how it works. Oh. This is the war on drugs. The brutal stories described above are not isolated incidents, nor are the racial identities of Irma Faye Stewart and Clifford Reynolds random or accidental. In every state across our nation, African Americans, particularly in the poorest neighborhoods, are subjected to tactics and practices that would result in public outrage and scandal if committed in middle-class white neighborhoods. In the drug war, the enemy is the racially defined. Although the majority of all illegal drug users and dealers nationwide are white, 3/4 of all people imprisoned for drug offenses have been black or Latino. Although the majority of illegal drug users and dealers nationwide are white, 3/4 of all people imprisoned for drug offenses have been black or Latino. There's a footnote on that. The notion that whites comprise the vast majority of drug users and dealers as may well be more likely than other racial groups. The notion that whites comprise the vast majority of drug users and dealers, and may well be more likely than other racial groups to commit drug crimes, may seem implausible to some given the media imagery we are fed on a daily basis, and the racial composition of our prisons and jail. Upon reflection, however, the prevalence of white drug crime, including drug dealing, should not be surprising. After all, where do whites get their illegal drugs? Do they drive to the ghetto to purchase them from somebody standing on the street corner? No. Studies consistently indicate that drug markets like American society generally reflect our nation's racial and socioeconomic boundaries. That's a profound sentence. Whites tend to sell to whites. Blacks tend to sell to blacks. University students usually University students tend to sell to other university students. Nevertheless, black men have been admitted to state prison on drug charges at a rate that is more than 13 times higher than white men. The racial bias inherent in the drug war is a major reason that 1 in every 14 black men was behind bars in 2006, compared with 1 in 106 white men. For young black men, the statistics are even worse. 1 in 9 black men between the ages of 20 and 35 was behind bars in 2006, and far more were under some form of penal control, such as probation or parole. These gross racial disparities cannot simply be explained by rates of illegal drug activity among African Americans. Defenders of mass incarceration point to violent crime rates in African American communities as a justification for the staggering number of black men who find themselves behind bars. The uncomfortable reality is that the arrests and the convictions for drug offenses, not violent crime, has propelled mass incarceration. So it's not the fact that our society is like Law and Order, SVU, and Criminal Minds. Yes, there are some serial killers out there. There are. But we don't have like 16 seasons with 32 episodes worth of mass murders out there and violent crimes. We do have a bunch of rape kits that are sitting around like not being tested in Texas and are growing mold. Now, I would consider that more pertinent and something that we should probably look into, other than trying to find some kid that's got a sack of weed on them. And if you find somebody on cocaine, it sounds like a them problem. Unless they're hurting people. Or domestic abuse. A lot of people turn their eye to... a lot of people... I'm not worried about it. It's not my problem. You turn your eye to domestic abuse all the time, but you're worried about a joint. I'm sorry. That's tangent. But so... Okay. The idea... So, our jails are filled with drug offenses. Basically what we're saying. And we have the highest incarceration rate in the world, and it is totally disproportionately black and brown. So, the idea that the criminal justice system discriminates in such a terrific fashion when few people openly express or endorse racial discrimination may seem far-fetched, if not absurd. How could the war on drugs operate in a discriminatory manner on such a large scale, with hardly anyone advocating or engaging in explicit race discrimination? Rather easily, it turns out. The process occurs in 2 stages. The first step is to grant law enforcement officials extraordinary discretion regarding whom to stop, search, arrest, and charge for drug offenses, thus ensuring the consensus and unconscious racial beliefs and stereotypes will be given free rein. So, the first step is they let them pull over whoever they want to. So, if everybody's racist, guess who they're going to target? Then, the damning step. Demand that anyone who wants to challenge racial bias in the system offer in advance clear proof that the racial disparities are the product of intentional racial discrimination, i.e., the work of a bigot. This evidence will almost never be available in the era of colorblindness because everybody knows, but nobody says anything, that the enemy in the war on drugs can be identified by race. Okay, there was, the evidence will almost never be available in the era of colorblindness because almost everyone knows but does not say that the enemy is the war on the enemy in the war on drugs can be identified by race. Okay, so colorblindness, it is one of our vocabulary words, and colorblindness means that you believe that race does not matter. And that is hunky-dory for you, but that is not how our society works, and that is not how our society was built. There are laws that are playing off of people's implicit biases, that it's a whole system. It's a whole system. So in the age of saying race doesn't matter, when in fact it does, it's just you're choosing not to see it. Like if you're a white person right now and you just are failing to see, if I want you to raise your hand if you want to be treated the way that people treat African Americans in this country. It was a test that was online. What's her name? Oh, I know her name. I'm getting off topic, but listen. Go and watch that. I'll post that on there. But if you didn't raise your hand, it's because you know exactly how they're treated, and you don't want to be treated like that. That's why you didn't raise your hand. But the fact that you knew and acknowledged that you didn't want that means that you know that there's something going on. I guess it's catch-22, whatnot. Picking and choosing, the role of discretion. Drug law enforcement is unlike most other types of law enforcement. When a violent crime or a robbery or a trespass occurs, someone usually calls the police. There is a clear victim and perpetrator. But with the drug crime, neither the purchaser of the drugs nor the seller has any incentive to call law enforcement. It is a consensual activity. Equally important, it is popular. In fact, in any given year, more than 1 in 10 Americans violate drug laws. But due to resource constraints and the politics of the drug war, only a small fraction are arrested, convicted, and incarcerated. It is impossible for law enforcement to identify and arrest every drug criminal. Strategic choices must be made about whom to target and what tactics to employ. Police and prosecutors did not declare the war on drugs, and some initially opposed it. But once the financial incentives for waging the war became too attractive to ignore, law enforcement agencies had to ask themselves, if we're going to wage this war, where should it be fought, and with whom should it be, and who should be taken prisoner? That question was not difficult to answer, given the political and social context. The Reagan administration launched a media campaign a few years after the drug war was announced in an effort to publicize horror stories involving black crack users and crack dealers in ghetto communities. Although crack cocaine had not yet hit the streets, when the war on drugs was declared in 1982, its appearance a few years later created the perfect opportunity for the Reagan administration to build support for its new war. Jimmy Reeves and Richard Camel show in their research how the media imagery surrounding cocaine changed as the practice of smoking cocaine came to be associated with poor blacks. Early in the 1980s, the typical cocaine-related story focused on white recreational users who snorted the drug in its powder form. These stories generally relied on news sources associated with the drug treatment industry, such as rehabilitation clinics, and emphasized the possibility of recovery. By 1985, however, the war on drugs moved into higher gear. This frame was supplanted by a new siege paradigm in which transgressors were poor, non-white users and dealers of crack cocaine. Law enforcement officials assumed the role of drug experts, emphasizing the need for law and order responses, a crackdown on those associated with the drug. A survey was conducted in 1995 asking the following question: would you close your eyes for a second and envision a drug user and describe that person to me? Close your eyes and envision a drug user. Don't tell me. Just think of it. Okay. 95% of respondents pictured a black drug user, while only 5% imagined other racial groups. These results contrast sharply with the reality of drug crime in America. African Americans constituted only 15% of current drug users in 1995, and they constitute roughly the same percentage today. Whites constituted the vast majority of drug users then and now, but almost no one pictured a white person when asked to imagine what a drug user looks like. The same group of respondents also perceived the typical drug trafficker as black. There is no reason to believe that the survey results would have been any different if police officers or prosecutors rather than the general public had been the respondents. Law enforcement officials, no less than the rest of us, have been exposed to the racially charged political rhetoric and media imagery associated with the drug war. In fact, for nearly 3 decades, news stories regarding virtually all street crime have disproportionately featured African American offenders. One study suggests that the standard crime news script is so prevalent and so thoroughly racialized that viewers imagine a black perpetrator even when none exists. In that study, 60% of viewers who saw a story with no image falsely recalled seeing one, and 70% of those viewers believed the perpetrator to be African American. Oh, listen to that. In that study, 60% of viewers who saw a story with no image falsely recalled seeing one, and 70% of those viewers believed the perpetrator to be African American. Decades of cognitive bias research demonstrates that both unconscious and conscious biases lead to discriminatory actions, even when an individual does not want to discriminate. The fact that you may honestly believe that you are not biased against African Americans and that you may even have black friends or relatives does not mean that you are free from unconscious bias. Implicit bias tests may still show that you hold negative attitudes and stereotypes about blacks, even though you do not believe you do and do not want to. Studies indicate that people become increasingly harsh when an alleged criminal is darker and more stereotypically black. They are more lenient when the accuser is lighter and appears more stereotypically white. This is true of jurors as well as law enforcement officers. The risk that African Americans would be unfairly targeted should have been of special concern to the U.S. Supreme Court, and one branch of government charged with the responsibility of protecting discrete and insular minorities from the excesses of the majoritarian democracy and guaranteeing constitutional rights for groups deemed unpopular or subject to prejudice. Yet when the time came for the Supreme Court to devise legal rules that would govern the war on drugs, the court adopted rules that would maximize, not minimize, the amount of racial discrimination that would likely occur. Oh, excuse me. Whew. As we shall see below, the Supreme Court has made it virtually impossible to challenge racial bias in the criminal justice system under the 14th Amendment, and it has barred the litigation of such claims under federal civil rights laws as well. Before we go on to closing the courthouse doors, let's do some questions. I'm going to read some questions out loud. Some of it's already been covered in the reading, and some of it we haven't. So I use text-dependent questions just to, kind of ask questions and kind of get you to think about it. Because if you can answer the question in your mind using your own words by going back through the text, then that makes you, it's like a cognitive stepping stone. So, how was the challenge addressed under the Reagan administration in order to build support for the war on drugs? Do you remember what the presidential administration, in order to build support for a complete and total racist policy, what'd they do to push it and advance it? How did the drug narrative, as covered by the media, shift from the early to mid-1980s? How did the role of law enforcement shift? What happened in the 1980s? The entire chapter, read by the author, chapter 3, is on my website. And there's a link to it, and it's audio, and it's right on there. And then this is just the guided reading part. Describe the two research-based examples the author provided to demonstrate the prevalence of implicit bias in the way people think about crime. Why do you think Alexander writes about implicit or unconscious bias in The Color of Justice as opposed to racism and bigotry? I think that's an important question. Racism and bigotry. What are those words? What do they mean? Go and, I could put them on the website if you would like. But racism and bigotry is different than implicit bias and unconscious bias. There's some times that I have, I had all sorts of it. You have to, catch it and relearn and let people of color call you on it and be like, I didn't like that. I don't think you understand what you said. And when they do it, don't get all, just listen. Listen. If they were listen. Why do you think the author writes about implicit or unconscious bias in this text, and as opposed to racism and bigotry? And in doing this, what potential counterclaims does she refute? How does the discussion of implicit bias relate to law enforcement officers? So how did she say that? What did she hypothesize would happen if you gave the exact same test to law enforcement officers and prosecutors? Who does the author place such an emphasis on the role and failure of the U.S. Supreme Court in her discussion of mass incarceration? Why does Alexander place such an emphasis on the role and failure of the U.S. Supreme Court in her discussion of mass incarceration? Okay, so we're working up to here, but this is a good part because we're going to cover the next ones, and I wanted you to be thinking about these before we got to them. What was the ruling in McCleskey versus Kemp in 1987? What are its implications for plaintiffs seeking to prove racial discrimination in sentencing? What relationship between McCleskey versus I forgot how I said it the first time. McCleskey versus Kemp, and the role of implicit bias in the disproportionate arrest, conviction, and sentencing of African American men. How is McCleskey versus Kemp used to reverse Judge Cowhill's ruling in the Edward Clary case? What is the job of a prosecutor? Why does the author state they have the most power in the criminal justice system? First, closing the courthouse doors. McCleskey versus Kemp. And I'm going to go ahead and spell it in case you want to search it. McCleskey versus Kemp. Kemp. First, consider sentencing. In 1987, when media hysteria regarding black drug crimes was at a fever pitch, and the evening news was saturated with images of black criminals shackled in courtrooms, and the Supreme Court ruled in McCleskey versus Kemp that racial bias in sentencing, even if shown through credible statistical evidence, could not be challenged under the Fourth Amendment in the absence of clear evidence of conscious discriminatory intent. Okay, listen. The Supreme Court ruled in McCleskey versus Kemp that racial bias in sentencing, even if shown through credible statistical evidence, could not be challenged under the 14th Amendment in the absence of clear evidence of conscious discriminatory intent. This reminds me of like all those cops who are like shooting like black people and going, oh, but he's a nice guy. Warren McCleskey was a black man facing death penalty for killing a white police officer during an armed robbery in Georgia. Represented by the NAACP in Legal Defense and Education Fund, McCleskey challenged his death sentence on the grounds that Georgia's death penalty scheme was infected with racial bias and thus violated the 14th and 8th Amendments. In support of his claim, he offered an exhaustive study of more than 2,000 murder cases in Georgia. 2,000 murder cases in Georgia. It's number 16. 16 in the footnotes. Even after accounting for 35 non-racial variables, the researchers found that defendants charged with killing white victims were 4.3 times more likely to receive a death sentence than defendants charged with killing blacks. Black defendants, like McCleskey, who killed white victims, had the highest chance of being sentenced to death in Georgia. Footnote 17. The case was closely watched by criminal lawyers and civil rights lawyers nationwide. The statistical evidence of discrimination that Baldus had developed was the strongest ever, presented to a court regarding race and criminal sentencing. If McCleskey's evidence was not enough to prove discrimination in the absence of some kind of racist utterance, what would be? This reminds me of, like, time right now when, like, they won't listen to science. But by a one-vote margin, the court rejected McCleskey's claims under the 14th Amendment, insisting that unless McCleskey could prove that the prosecutor in his particular case had sought the death penalty because of race, or that the jury had imposed it of racial reasons, the statistical evidence of race discrimination in Georgia's death penalty system did not prove unequal treatment under the law. I mean, and now they're... There is good reason to believe that despite appearances, the McCleskey decision was not really about the death penalty at all. Rather, the court's opinion was driven by a desire to immunize the entire criminal justice system from claims of racial bias. Which I think, excuse me, give me one second. I think is awfully telling. And moving on. Sorry, this is such a long chapter. I just can't get off topic. Cracked up. Discriminatory sentencing and the war on drugs. Anyone who doubts the devastating impact of McCleskey versus Kemp on African American defendants throughout the criminal justice system, including those ensnared by the war on drugs, need only ask Edward Clary. 2 months after his 18th birthday, Clary was stopped and searched in the St. Louis airport because he looked like a drug courier. At the time, he was returning home from visiting some friends in California. One of them persuaded him to take home some drugs back to St. Louis. Clary had never attempted to deal drugs before, and he had no criminal record. Texas and allergies. Clary, like defendants in other crack cases, alleged that constitutionally of the 100-to-1 ratio. His lawyers argued that the law is arbitrary and irrational because it imposes such vastly different penalties on two forms of the same substance. They also argued that the law discriminates against African Americans because the majority of those charged with crimes involving crack at the time were black. Approximately 93% of convicted crack offenders were black. 5% were white, whereas powder cocaine offenders were predominantly white. Judge Clyde Cowhill of the Federal District of Missouri. Judge Clyde Cowhill of the Federal District of Missouri, an African-American judge, was assigned to Clary's case, boldly challenged the prevailing view that courts are powerless to address forms of race discrimination that are not overtly hostile. The 100-to-1 ratio coupled with mandatory minimum sentencing provided by federal statute has created a situation that reeks with inhumanity and injustice. If young white males were being incarcerated at the same rate as young black males, the statute would have been amended long ago. Judge Cowhill sentenced Clary as if the drug he had carried home had been powder cocaine. The sentence imposed was 4 years in prison. Clary served his term and was released. The prosecution appealed Clary's case to the 8th Circuit Court of Appeals, which reversed Judge Cowhill in a unanimous opinion, finding that the case was not even close. In that court's view, there was no credible evidence that the crack penalties were motivated by any conscious racial bigotry. As required by McCleskey versus Kemp, the court remanded the case back to the district court for resentencing. Clary, now married and a father, was ordered back to prison to complete his 10-year term. No one has more power in the criminal justice system than prosecutors. The prosecutor is free to dismiss a case for any reason or no reason at all, regardless of the strength of the evidence. The prosecutor is also free to file more charges against the defendant than can be realistically be proven in court, so long as probable cause arguably exists. Whether a good plea deal is offered to a defendant is entirely up to the prosecutor. And if the mood strikes, the prosecutor can transfer drug defendants to the federal system, where the penalties are far more severe. Juveniles, for their part, can be transferred to adult court, where they can be sent to adult prison. The most comprehensive studies of racial bias in the exercise of prosecutorial and judicial discretion involve the treatment of juveniles. These studies have shown that youth of color are more likely to be arrested, detained, formally charged, and transferred to adult court and confined to secure residential facilities than their white counterparts. As African American youth account for 16% of all youth, 28% of all juvenile arrests, 35% of all youth waived to adult criminal court, and 58% of youth admitted to the state adult prison. What? Those are some crazy numbers. A major reason for these disparities is unconscious and conscious racial bias infecting decision-making. Prosecutors are well aware that the exercise of their discretion is unchecked, provided no explicitly racist remarks are made. As it is next to impossible for defendants to prove racial bias, it is difficult to imagine a system better designed to ensure that racial bias and stereotypes are given free rein, while at the same time appearing on the surface to be colorblind, than the one while at the same time appearing on the surface to be colorblind than the one devised by the U.S. Supreme Court. In defense of the all-white jury, the rules govern... Yeah, I read that right. The rules governing jury selection provide yet another illustration of the court's complete abdication of its responsibility to guarantee racial minorities equal treatment under the law. In 1985, in Batson v. Kentucky, B-A-T-S-O-N, the court held that the 14th Amendment prohibits prosecutors from discriminating on the basis of race when selecting juries, a ruling held as an important safeguard against all-white juries locking up African Americans based on racial biases and stereotypes. Can we just remember, though, real fast, that you can't serve on a jury if you've been to, like, prison and for, like, so many years, or you... Hold on. There's something that you lose the right to be on a jury. We're about to get to that. Notwithstanding Batson's formal prohibition on race discrimination in jury... Notwithstanding Batson's formal prohibition on race discrimination in jury selection, the Supreme Court and lower federal courts had tolerated all but the most egregious examples of racial bias in jury selection. Both prosecutors and defense attorneys are permitted to strike preemptorily jurors they don't like. That is, people they believe will not respond favorably to the evidence or witnesses they intend to present at trial. Lawyers typically have little information about potential jurors, so their decisions to strike individual jurors tend to be based on nothing more than stereotypes, prejudices, and hunches. Achieving an all-white jury, or nearly all-white jury, is easy in most jurisdictions because relatively few racial minorities are included in the jury pool. Potential jurors are typically called for service based on the list of registered voters or Department of Motor Vehicle lists. Sources that contain disproportionately fewer people of color, because people of color are significantly less likely to own cars or register to vote. Making matters worse, 31 states and federal governments subscribe to the practice of lifetime felon exclusion from juries. As a result, about 30% of black men are automatically banned from jury service for life. So if you don't have any black men representing black men in our court systems, especially at jury, which is your civic duty, the practice of systematically that was my rant, not the book. The practice of systematically excluding black jurors has not been halted by Batson. The only thing that has changed is that prosecutors must come up with race-neutral excuses for the strike, an exceedingly easy task. Courts accepted explanations that jurors were too young, too old, too conservative, too liberal, too comfortable, too uncomfortable. Clothing is also a favorite reason. Jurors have been stricken for wearing hats or sunglasses. Even explanations that might not correlate with race, such as lack of education, unemployment, poverty, being single, living in the same neighborhood as the defendant, or prior involvement with the criminal justice system, all have been accepted as perfectly good, non-pretextual excuses for striking African Americans from juries. Hollow hope, the purpose of our Constitution. Sorry that my allergy's been acting up. The purpose of our Constitution, especially the 14th Amendment's equal protection guaranteed, is to protect minority rights even when, or especially when, they are unpopular. So shouldn't African American defendants be able to file a successful lawsuit demanding an end to these discriminatory practices, or challenge their drug arrests on the grounds that these law enforcement practices are unlawfully tainted by race? The answer is yes, they should, but no, they probably can't. Adolph Lyons' attempt to ban the use of lethal chokeholds by the Los Angeles Police Department is a good example. Lyons, a 24-year-old black man, was driving in his car in Los Angeles one morning when he was pulled over by 4 police officers for a burned-out taillight. With guns drawn, police ordered Lyons out of his car. He obeyed. The officers told him to face the car, spread his legs, and put his hands on his head. Again, Lyons did as he was told. After the officers completed a pat-down, Lyons dropped his hands, promoting an officer to slam Lyons' hands back on his head. When Lyons complained that the car keys he was holding were causing him pain, the officer forced Lyons into a chokehold. He lost consciousness and collapsed. When he awoke, he was spitting up blood and dirt. He had urinated and defecated on himself and had suffered permanent damage to his larynx. Footnote 22. The officers issued a traffic ticket for the burned out taillight and released him. Pardon my French, but you got a broken taillight and you just happen to be black, so I guess we're going to beat the fuck out of you. And then we're still going to give you a ticket. What? You know, if that happened to somebody's white daddy or somebody's white sister or white brother, there would be hell to pay. Lyons sued the city of Los Angeles for violation of his constitutional rights and sought as a remedy a ban against future use of chokeholds. By the time his case reached the Supreme Court, 16 people had been killed by police with the use of a chokehold, 12 of them black men. The Supreme Court dismantled the case, however, ruling that Lyons lacked standing to seek an injunction against this deadly practice. So I guess somebody who's been in a chokehold can't say anything about other people being in a chokehold. In order to have standing, Lyons would have not only had to allege that he would have had another encounter with police, but also make it... In order to have standing, Lyons would have had not only to allege that he would have another encounter with the police, but also to make the incredible assertion either, 1, that all police officers in Los Angeles always choke any citizen with whom they have an encounter, whether for the purpose of arrest, issue of citation, or for questioning, or 2, that the city ordered and authorized the police to act in such a manner. The court's ruling in Lyons makes it extremely difficult to challenge systematic race discrimination in law enforcement and obtain meaningful policy reform. Let's see. Give me 1 minute. I think we're going to go ahead and do the next. Yep. We're going to do last 6 questions. What does research suggest about the role of bias in prosecutorial decision-making? What does the law say about the role of bias, and who suffers the most harm from this discretion? What does research suggest about the role of bias in prosecutorial decision-making? What does the law say about that, and who suffers the most harm from this discretion? Discretion is a word on our vocabulary list. Alexander points out that while black men are disproportionately targeted in the war on drugs, they are underrepresented when it comes to jury selection. Why is that? According to the Supreme Court, what did Adolph Lyons need to show in order to prove that the LAPD's use of a chokehold was discriminatory? In your opinion, is that reasonable burden of proof? Is it possible to even show? Are the police authorized to use race as a factor in deciding whom to stop and search? Are they allowed to use race as a sole factor in making such determinations? Police departments may defend against charges of racial profiling by pointing to a number of other factors, in addition to race, that inform their decisions about who to stop and search. But what skepticism does Alexander raise about these seemingly race-neutral factors? Do you agree with her statement? The excerpt concludes with the statement, The excerpt will conclude with the statement, the system of mass incarceration for now, for all practical purpose, thoroughly immunized from claims of racial bias. Explain the takeaway message. In your opinion, what are the two most convincing pieces of evidence Alexander provides in The Color of Justice to support her thesis? So, let's see. Race is a factor. Police departments and highway patrol agencies frequently declare, "We do not engage in racial profiling," even though their officers routinely use race as a factor when making decisions regarding whom to stop and search. The justification for the implicit doublespeak, "We do not racial profile, we just stop people based on race," can be explained in part by the Supreme Court's jurisprudence. Ooh, I want to put that word down on our thing. I forgot I ran into that. Jurisprudence. Jurisprudence. I like that. The Supreme Court has authorized the police to use race as a factor when making decisions regarding whom to stop and search. And police departments believe that racial profiling exists only when race is a sole factor. Thus, if race is only one factor but not the only factor, then it doesn't really count as a factor. If you got a pig and it's with a bunch of other pigs, then it's not a pig anymore. The problem is that although race is rarely the sole reason to stop and search, it is frequently a determinative reason. Similarly situated people inevitably are treated differently when police are granted permission to rely on racial stereotypes when making discretionary decisions. The sole factor test ignores the way in which seemingly race-neutral factors, such as location, operate in a highly discriminatory fashion. Subjecting people to stops and searches because they live in high-crime ghettos cannot be said to be truly race-neutral, given that the ghetto itself was constructed to contain and control groups of people defined by race. In Note 24. Even seemingly race-neutral factors such as a prior criminal history are not truly race-neutral. A black kid arrested twice for the possession of marijuana may be no more of a repeat offender than a white frat boy who regularly smokes pot in his dorm room. But because of his race and his confinement to a racially segregated ghetto, the black kid gets a criminal record, while the white frat boy, because of his race and relative privilege, does not. Thus, when prosecutors throw the book at black repeat offenders, or when people stalk ex-offenders and subject them to regular frisks and searches on the ground, that it makes sense to watch criminals closely, they are often exacerbating racial disparities created by the discretionary decision to wage the war on drugs, almost exclusively to poor communities of color. So, if you're black and caught with marijuana, it's going to be way worse than if you're white and caught with marijuana, because a whole bunch of college kids smoke marijuana all the time. It's just, I guess if you're white or black. Or, and this isn't even about drugs, but Brock Turner, he just drugged some girl behind a dumpster and raped her, and he got 3 months. But we're talking about kids who smoked some marijuana sometime. Studies of racial profiling show that police do, in fact, exercise their discretion, their discretion regarding whom to stop and search in the drug war in a highly discriminatory manner. In New Jersey, the data showed that only 15% of all drivers in New Jersey Turnpike were racial minorities. Yet 42% of all stops and 73% of all arrests were of black motorists. Despite the fact that blacks and whites violated traffic laws at almost exactly the same rate, a subsequent study conducted by the Attorney General of New Jersey found that searches on the Turnpike were even more discriminatory than the initial stops. 77% of all consent searches were of minorities. Footnote 26. What most surprised many analysis was that whites were actually more likely than people of color to be carrying around illegal drugs or contraband in their vehicles. In fact, in New Jersey, whites were almost twice as likely to be found with illegal drugs or contraband as African Americans, and 5 times as likely to be found with contraband than Latinos. Although whites were more likely to be guilty of carrying drugs, they were far less likely to be viewed as suspicious, resulting in relatively few stops, searches, and arrests of whites. Pedestrian stops, too, have been the subject of study and controversy. The New York Police Department released statistics in February 2007 showing that during the prior year, its officers stopped an astounding 500,000 people. On average, that's 1,393 people per day who were walking down the street, perhaps on their way to the subway, grocery store, or bus stop. Often the stops included searches for illegal drugs or guns, searching that frequently required people to lie face down on the pavement or stand spread eagle against the wall, while police officers aggressively groped all over their bodies while bystanders watched or walked by, and the vast majority of those stopped and searched were racial minorities, and more than half were African Americans. The end of an era. In a little notice case called Alexander versus Sandoval, decided in 2001, the Supreme Court eliminated the last remaining avenue available for challenging racial bias in the criminal justice system. Sandoval was not, on its face, even about criminal justice. It was a case challenging the Alabama Department of Public Safety's decision to administer state driver's license examinations only in English. The plaintiffs argued that the department's policy violated Title VI, the Civil Rights Act of 1964, and its implementing regulations because the police had the effect of subjecting non-English speakers to discrimination based on their national origin. The Supreme Court did not reach the merits of the case, ruling instead that the plaintiffs lacked the legal right even to file a lawsuit. It concluded that Title VI does not provide private right of action to ordinary citizens, the civil rights groups, meaning that victims of discrimination can no longer sue under the law. It concluded that it does not provide a private right of action to ordinary citizens and civil rights groups, meaning that victims of discrimination can no longer sue under the law. The Sandoval decision virtually wiped out racial profiling litigation nationwide. Nearly all of the cases alleging racial profiling in drug law enforcement were brought pursuant to the Civil Rights Act of 1964 and its implementing regulations. After Sandoval, only the federal government can sue to enforce Title VI's anti-discrimination provisions, something it is neither the inclination nor the capacity to do in most racial profiling cases due to its limited resources and the institutional reluctance to antagonize law enforcement. The Supreme Court has now closed the courthouse doors of claims of racial bias at every stage of the criminal justice process, from stops and searches to plea bargaining and sentencing. The system of mass incarceration is now, for all practical purposes, thoroughly immunized from claims of racial bias. So, that is Chapter 7, or that's Chapter 3, Lesson 7. Chapter 3, Lesson 7, guided reading. I've hit on some of the questions. Some argue that since drug use and sales are non-violent and consensual acts, there are no victims and therefore should be made legal. What do you think? I do, and I'll tell you why. I think that marijuana should be legal everywhere. And I also think that if we made all drugs legal, then, number one, all the money that we're wasting on keeping all these people in prison could go towards rehab and mental health and doctor's appointments, because drug addiction, like if you got hooked on opiates, and that's like or you're an alcohol, like that's a sickness. You need help. You need counseling. You need help to get out of that hole. You can't just be punished into staying into the hole. So, and funds could be allocated elsewhere. And I mean, how much is that? Why are we really so worried about some marijuana that's why we're not worried about all those women in Texas getting raped? Is that really what we're saying here? Is that the priority? Kids who smoke some weed are more important than all those women who got raped? Seems a little fucked up. On the whole, how does the color of justice characterize law enforcement officials? How does that assessment compare with your view of the police, your families, or your communities?
I personally have law enforcement in my family, and I really like my cousin, and I just really don't think that she would, I don't think she'd say some of that stuff, and I don't know, I don't think she'd shoot a kid. I know my cousin, I don't think she would. I don't think she'd call somebody out for being, like, crazy. Or, like, maybe, like, you should be I think she would. I mean, my cousin's got bigger balls than a lot of people do. What is implicit bias? Describe an example of an implicit bias that you have experienced or observed that led to discriminatory actions or behaviors. Think about going back to school. Greenwood schools. Greenwood schools had most schools in Arkansas have those kind of things. Especially down here by the border. There's a bunch of stuff going on down here that's like pretty racially charged, or people say super racist things. But it's just different from the South, because they're like, it's directed at a different group, I guess. But, okay, well, anyway, thank you for joining me. Have a wonderful day.